further hearing in R on the application of Somalia and others against Secretary of State for the Home Department.
Mr. Wilson.
May it please your Lordship. My Lord, I was about to move on from the Procedures Directive, but there are still one or two things to deal with. The first arises out of the reference to Brent and the authorities that your Lordship asked us to look at,
yes,
which were referred to in the footnote.
Yes.
My Lord, what we have done is to find those authorities. We have put them in a supplemental bundle, which is just behind you, which is referred to as Authorities 8. And I ask your Lordships, first of all, to go to tab 85, that's volume 6.
This is Mr. Brent's book.
It's Mr. Brent's book, my Lord. At paragraph 1921.
Yes.
And
Page 2.
page 268.
Oh, yes, yes, where we were yesterday.
Yes, indeed, my Lord.
These are the footnotes.
Yeah.
Yes.
Yeah.
And this goes to the point as to whether or not the Court of Appeal were entitled or indeed obliged to have reference to subsequent European legislation. And my Lord would see, your Lordships will see, that two-thirds of the way down the paragraph 1921, it states that the Court found corroboration for its definition and later legislation on tax exemptions for certain means of transport was confirmatory of the Court's interpretation of the exception from the exemptions in the 6th VAT directive. Then we have footnote 133. And in the footnote, the three cases referred to there are the ones that we have in the bundle. And at tab 97, it's the case of Haman, and your Lordships will see, if you turn over the first page, page 769, that the preliminary question on which a ruling was sought was, we look at paragraph 10, just under it, is Article 9.2d of the 6th Directive to be interpreted as meaning that ocean-going sailing yachts that are used by their hirers for the practice of the sport of sailing are to be regarded as forms of transport within the meaning of that directive. And then there is at paragraph 21, paragraph 20, first of all, it says this interpretation...
Sorry, are we now in the judgment, or are we...
We're now in the judgment, my Lord, at page 784.
Yes.
Thank you.
And, my Lord, the short point is that a certain interpretation is set out in paragraph 19. In paragraph 20, they say this interpretation is confirmed by Article 15.2 of the 6th Directive, according to which pleasure boats, the category to which ocean-going sailing yachts belong, are means of transport for private use. Then, paragraph 21, the precise paragraph referred to by Mr. Brent, the same interpretation was also adopted in Council Directive 83 of 28th of March 1983 on tax exemptions within the community for certain means of transport temporarily imported into one member state from another official journal, from another, Article 1.1 of which provides that pleasure boats are within the scope of the directive and are therefore covered by the term certain means of transport. This was a subsequent piece of legislation. My Lords, the next case is towards the front of the bundle, tab 96. It's the next case referred to in the footnote. It's the case of Harbourman. In this case, the relevant passage is to be found in the opinion of the Advocate General as opposed to the judgment. but we would say that is persuasive of the appropriate approach in any event. And, my Lords, if you turn to the second page, which is headed Opinion of Advocate General, and, my Lords, paragraph 1, the questions referred to this court for a preliminary ruling concern the interpretation of certain provisions of Council Directive 76 of 9th of February 1976 on the implementation of the principle of equal treatment for men and women as regards access to employment, vocational training and promotion, and working conditions. And then in the next paragraph, the National Court wishes to ascertain in particular whether, according to and for the purposes of that directive, the application of national legislation which, by prohibiting nighttime work during pregnancy, allows a contract of employment concluded between an employer and a pregnant employee, both unaware of the pregnancy at the time the contract was made, to be considered invalid or to be terminated, is compatible with the principle of equal treatment. And then, if your Lordships turn to page 1665, and look at paragraph 14, and just below that, there is this passage that Mr. Brent is specifically referring to. Although that directive has not come into force,
Not yet. No.
not yet come into force, its transposition into national law is to be completed by October 1994, the aforesaid provisions support the interpretation given here of Article 5.1 of the directive, which is that a contract of employment may not be terminated on account of pregnancy, even where there is a statutory prohibition on nighttime work. My Lords, the next case in the footnote is to be found at tab 98. And there are two relevant passages. One is in the opinion of the Advocate General, and the other is in the judgment of the court itself. And, my Lords, if your Lordships would turn over one page to page 7213, the opinion of the Advocate General sets out in the introduction what the matter is about. In this paragraph 1, in this case, the Court of Justice has been asked to give a ruling on the provisions of Directive 68-151, and more especially the provisions concerning the limits placed on the conferment of powers of representation on the directors of a company, as well as to determine in what circumstances a conflict of interests involving the directors may be relied upon as against third parties. And that having been set out, we go to the judgment of the court at page 7221.
Are you going to refer to page 7217? This is the Advocate General, paragraph 9.
My Lord, yes. My analysis is also borne out by the proposal for a fifth company directive. In that text, the Commission has actually proposed the adoption of specific rules, making it possible to adduce, as against contracting third parties, a conflict of interest involving the organ representing the company, but only where the company proves that the third party was aware of the irregularity of the act, or that, given the circumstances, it could not have been unaware thereof. Article 10.4. The very fact that the Commission considered it necessary to propose legislating on conflicts of interest also indicates that the directive itself does not regulate situations of that nature. And then, my Lord, to the judgment at page 7221. By judgment of 22nd of March 1996, received at the court, referred 3 questions to the court for a preliminary ruling, to Article 177 of the EC Treaty concerning the interpretation of Article 9.1 of the First Council Directive 68151, 9th of March 1968, on coordination of safeguards which for the protection of the interests of members and others are required by member states of companies within the meaning of the second paragraph of Article 58 of the treaty, with a view to making such safeguards equivalent throughout the community.
And
then,
without taking up too much time on it, is it paragraph 25 in the judgment that
my Lord, that's it.
point up again?
Indeed.
Yes. Thank you very much. Well, I think it may be worth mentioning, Mr. Wilson, that if you look at the documents referred to in the first page of the directives themselves, the originating documents, which I drew your attention to yesterday, you find that the proposals were made in the following order, and I'm looking actually at the proposal for the reception directive. But what it does, it narrates that the proposal for procedures, minimum standards on procedures, was made by the Commission on the 20th of September 2000, and that it was following that, early in 2001, that the Commission proposed a Council directive on minimum standards on the reception of applicants for asylum. And it's quite clear from the overview, which is set out in this paper, that they were looking at reception, as it's put, at all stages and in all kinds of asylum procedures. They wanted to identify the reception conditions available to applications, as it's put elsewhere, at various stages or types of asylum procedures. And it's of considerable interest that in the definition of applicant in the original draft, there was a cross-reference to the procedures directive. It said the applicant means a third country national or a stateless person who's made an application for asylum in respect of which a final decision has not yet been taken, and that's in the existing directive. And it adds, a final decision is a decision in respect of which all possible remedies under Council directive, the numbers are not given because it hadn't been enacted yet, on the minimum standards for procedures have been exhausted. So there was a specific cross-reference. It was then taken out because the Procedures Directive got delayed by discussion with Member States about the procedures. The Reception Directive caught up and passed it by. So this had to be taken out by amendment, which is why we don't find the reference there anymore. But the legislative history does support, I think, your position that these two should be read together.
My Lord, yes. And as your Lordship alluded to, perhaps yesterday, it would explain, for instance, why there's no definition in the Reception Directive of final decision or procedures at first instance, because, as your Lordship has just indicated, at the time it was drafted, it was anticipated that perhaps they'd be passed in a different order.
Yes. Well, either that or simultaneously. But anyway, it didn't happen that way around. It's thrown up this problem, but the answer to it really is to be found in looking back at the originating documents.
My Lord, yes, I'm grateful for that. And indeed, my Lord, on that, His Honour Judge Mackey, in the core bundle appendix part 1, and his judgment begins at page 26. And what he says at page 35, paragraph 36, it's something which my learned friends for MM specifically draw to the court's attention in their case on her behalf. At paragraph 36, Judge Mackey states, in my judgment, the position is as follows. First, no fine points or distinctions arise over the approach to the interpretation of the directives for the reasons I've given. If there were to have arisen, I've not been equipped with the material to evaluate them. But secondly, these directives clearly interlinked and must be construed with each other in mind. The expressions are used interchangeably and each gives guidance as to the approach to be taken by the other.
All his paragraphs in my copy of his judgment are numbered 72, but this is at page 35 of the...
Well, my lord, I do apologise because we thought we had covered that problem. Right, my lord, in the core volume,
Oh, I see.
It is corrected. That's what I'm reading from. So,
Yes.
in the core
Never mind,
volume, at page 35, that
So that is
error
paragraph 36.
has been picked up, and it's at paragraph 36.
Yes.
And, my lord, simply by way of comment, the learned judge's observation at the time accorded with the Secretary of State's own position on it. And what we have with the Secretary of State through the history of this case is a very peculiar odyssey with their approach with regards to the Procedures Directive. And, my lords, if I can just start off with Appendix Part 2, page 315. The document begins at 306, and your lordships will see it's the detailed grounds of defence put in by the filed by the Secretary of State, and it's dated the 6th of June 2008. And at paragraph 24 to 26, Secretary of State sets out their position on the Procedures Directive. In paragraph 24, they set out the fact that it is one of 4 measures so far adopted with regards to a common asylum system. At paragraph 25, they state this: as these 4 legal instruments form part of a general scheme developed by the community, it is appropriate to consider them in assessing the interpretation of the Reception Directive. And then in paragraph 26, we have this: in this context, it is noted that the Procedures Directive on minimum standards on procedures in member states for granting and withdrawing refugee status refers to a number of matters also referred to in the Reception Directive. Although the terms of the Procedures Directive would not have applied in the present case by reason of the relevant dates for implementation, the interpretation of the Reception Directive should be consistent with the Procedures Directive insofar as possible. My lord, there is then the skeleton argument of the 9th of December 2008, which is put in by the Secretary of State before the Court of Appeal. And, my lord, that begins at page 383. And I ask your lordships to turn to paragraph 35. Because there's now a shift in position at paragraph 35. It begins in the same way. It is noted that the Procedures Directive refers to a number of matters also referred to in the Reception Directive. However, the Procedures Directive was adopted and implemented after the Reception Directive and would not have applied in the present case by reason of its later date for implementation. Nonetheless, as these legal instruments form part of a general scheme developed by the community, it is appropriate to consider the Procedures Directive in assessing the interpretation of the Reception Directive, albeit that the Procedures Directive's later implementation may affect the extent to which it may be said to modify any interpretation of the Reception Directive. And then, my lord, we have a further change in the position by the time we come to the petition to this court. And if your lordships would now turn to the core bundle. The petition is the first document in the core bundle, and paragraphs 46 to 48 deal with the relevance of the Procedures Directive. And what is said between paragraph 46 to 48, paragraph 47, if we begin with that. However, the reception directive must have had a settled meaning by the time its transposition into national law, which would have remained its meaning even if the procedures directive had never been finalised. The Court of Appeal's judgment demonstrates that if the reception directive is considered on its own, it is far from clear that it bears the meaning decided by the Court of Appeal. To reach that conclusion, the Court of Appeal had to place great weight on the procedures directive. This, in turn, demonstrates the arguability of the Secretary of State's construction. And then goes on to make certain detailed points about the procedures directive. We then end up with the Secretary of State's case before this court, in which the Secretary of State submits, and this is dated the 16th of April 2010, submits that the Court of Appeal was wrong to refer to and rely on the procedures directive as an aid to interpretation.
So which paragraph in the case you're looking at?
Well, my Lord, if I can just turn that up.
It's paragraph 97, page 28.
My Lord, I'm most grateful. My Lord, yes. So, my Lord, we would submit that that odyssey has been as a result of the force of the aid that the procedures directive does supply to the court. And there's been a shift of position from a starting point in the High Court to a point where it said, now the Court of Appeal was even wrong to refer to it, which, as we can see from the authorities we've looked at this morning, is contrary to authority and wrong in principle. So, my Lord, the final point to make before leaving the procedures directive is to take your lordships to the place in the bundle where the transposition note for the procedures directive is, because your lordships will recall that yesterday I said the Secretary of State had chosen, for instance, not to incorporate into English law Article 32 and also Article 23. And my Lords, that's to be found at tab 19.
Bundle?
Bundle, Volume 1, Authorities Bundle 1. My Lords, unfortunately, these pages are not numbered. Your Lordships will see on the first page, it's a transposition note prepared by the Home Office. And that it is seeking to transpose into UK law the procedures directive. If your Lordships turn over the pages to Article 32, on the left-hand side it indicates the article which has been transposed, as your Lordships will know, and go to 32 on the left-hand side, which deals with subsequent applications. And if your Lordships would also care to have open before you the procedures directive at Article 32, it can be seen which specific parts of that article are being referred to. So, if we look at Article 32 of the procedures directive, Article 32(2) deals with member states being permitted to apply a specific procedure referred to in paragraph 3. Paragraph 3 refers to a preliminary examination for a subsequent application. And then paragraph 4 also deals with that. And then there's paragraph 7. We can see in the transposition note, under the heading implementation, the second sentence which begins as regards Article 32. As regards Article 32(2) to 4 and 7, which allow Member States to apply a specific procedure to further submissions and applications in certain circumstances, no action required. The UK is not establishing this kind of special procedure, and then took the view in relation to 32(5) that no action was required. My Lords, if your Lordships would now turn to Article 23 of the Procedures Directive and have that open in front of you, and then do
23.
Article 23, my Lord, and then do the same in the implementation, the transposition note, and go to Article 23. And, my Lords, looking at the Procedures Directive, Article 23, we can see that deals with examination procedure, and that Article 23(3) deals with Member States may prioritise or accelerate any examination in accordance with the basic principles in Chapter 2, including where the application is likely to be well-funded or where the applicant has special needs. And then 23(4). Member States may also provide that an examination procedure in accordance with the basic principles and guarantees of Chapter 2 be prioritised or accelerated if, and we will note from yesterday that my Lord Hope referred to 4E. The applicant has filed another application for asylum stating other personal data, and then at 23H, the applicant has submitted a subsequent application which does not raise any relevant new elements. And if we look now at the transposition note, Article 23, at the foot of that page, the last 3 lines, as regards Article 23 and 4, no action required was the view taken by the Secretary of State.
And is that because the matter was already dealt with in the rules?
My Lord, that may well be the view taken by the Secretary of State.
Clearly, he needed to put in something to deal with 23(2), which introduced the 6-month time limit for giving information, and that's all set out.
Yes, one can, I suppose, infer, and it's be an inference from the language used, no action required, that the view taken, perhaps by the Secretary of State at that time, was that there were sufficient domestic measures in place to do the same thing. But
have we got special measures in place to prioritise or accelerate? I'm not aware of them.
I'm not aware of them. I don't know what my learned friend is going to say for the Secretary of State. But that the view taken in relation to this was that the United Kingdom didn't require, no action was required.
I mean, I'm sorry, but 23, unlike 32, doesn't go to subsequent applications, but...
well, my Lord, it does, in 23H, 23(4)H.
Of course, absolutely, I'm so sorry, you're
Yeah.
absolutely right. But I mean, can I just be clear? I mean, the only rule I think I'm aware of in the UK immigration rules that goes to subsequent applications, further submissions, is 253.
My Lord, yes.
Or 3, what, I can't remember. What is it?
353, yes.
And 353, 353 has got nothing to do with prioritising anything. Indeed, of course, as we know, under our system, it's on the contrary. But what it does do is require a substantive determination, first instance determination,
Yes.
followed by, in effect, a second determination. Is it to regard as a fresh claim and thereby attract appeal rights? I mean, that's the way it works. But it doesn't deal with these. So what does, if anything? Nothing. They've just decided not to take advantage of the opportunity given under this directive to have in place some short-circuiting scheme.
My Lord, yes.
I suppose the point would be this, that 23(2) is mandatory. You've got to give, if you can't take the decision with 6 months, you have to give the information that's set out there, and that had to be provided for, whereas 23(3) and 4 are permissive. And perhaps the view was taken that the system was robust enough not to need these extra provisions in it. I mean, I no doubt we'll be told, but that might be an explanation.
That might be the explanation, but it's perhaps to be looked at in the sense of what has happened on the ground. And a view may well be taken, it's certainly our view, that to have adopted 32 and to have adopted 24, 3 and 4, would have been of some significant assistance in preventing the build-up of the legacy cases. But that was a policy decision. And so far as, but its relevance is in the context of the Court of Appeal's interpretation and whether that interpretation, as the Secretary of State submits, leads to abuse. The burden of our submission is that the panoply of procedural measures which are put in place by the Procedures Directive are sufficient if adopted and if properly used with appropriate resources to deal with the question of abuse.
I mean, before the Procedures Directive came into force, presumably it was simply up to each individual member state to do whatever it wanted in terms of dealing with any abuse. I mean, this obviously then puts constraints on that or formalises it. I mean, puts a structure within which it can operate.
My Lord, yes, and as is made plain in the preamble, the reasoning behind that is that to prevent asylum seekers forum hopping, so to speak, or country hopping, because one country's minimum reception conditions are perceived to be better than another. And that's one of the major aims behind a common European asylum system. So, my Lord, I move away now from the Procedures Directive, unless there's anything further your Lordships would wish me to deal with.
No, I don't think so. Thank you very much.
My Lords, with regards to the purpose, scope and operative provisions of the Reception Directive, we submit that there is nothing in the language of any of those provisions which exclude a subsequent application. We have made a detailed textual analysis in the written case for ZO, my Lords, that is set out in our case, and we commend those passages to you. My Lords, your Lordships will perhaps have noted that we, unlike the Secretary of State, have not restricted ourselves to looking solely at Articles 5 and 6 and 9 and 10, but we have dealt with all of the operative articles. And the general position is the same with all of them. And, my Lord, each of those articles can be read so that a subsequent application would fall within its ambit. My Lords, I don't propose to take up time on that, as we've got it in the written case.
I don't think Mr. Tam really disputed that. I think he at the very beginning of his submission, I think he said, taken literally, that would be so, but he disputes, of course, strongly the literal approach for which you're arguing. So I think the detail isn't really helpful. I think it's...
Can I just, I'm sorry, I mean, on 10.2, I mean, 10.2 can't actually come into play in respect to the second application, can it? But you probably, I mean, you simply say, so what?
My Lord, I'll just go to 10.2 of the Reception Directive.
Yeah. And that can only have application to a first application.
Well, my Lord, perhaps not. Let's take the case of the babe in arms at the time of the first application for asylum.
Yeah.
So the babe in arms would not be a person who would be looking to have, or be able to have, I think is a better word, not be capable of having access to the educational system. But by the time a subsequent application is made, that babe in arms may now be of school age. And in those circumstances, we would submit to prevent that child from having access to the educational system would be in breach.
No, I follow.
Yeah.
I follow that. Why doesn't that babe come in under 10.1? I mean, the point you're about to make is that you can delay it for 3 months for that no longer babe who's now within educational age. But why can't you do better than that under 10.1 and say you can't? But
Well, for this reason, my lord, the status of asylum seeker may come and go.
I see. So you say that once the first decision is finally rejected, first application is finally rejected, then under 10.1, he's no longer an asylum seeker, and even though he's left in the country.
That's an absurd construction, surely. I mean, one has got to treat this in a sensible way, and the words "for so long as an expulsion measure against them or their parents is not actually enforced" could not be clearer.
Well, my lord, I just wonder whether I'm at cross purposes with your lordship at this point, because what it's stating is that member states shall grant to minor children, asylum seekers who are minors, access to the educational system under conditions for so long as an expulsion measure against some of their parents is not actually enforced. Well, my lord, I take your lordship's point on that.
Well, I had thought, I may be wrong, Mr. Wilson, I thought that you were concentrating on the point that first paragraph assumes that at the date of the application by the asylum seeker, the children, the firstborn child was a minor.
My lord,
And that might not be so. I mean, it may be that they're younger than would be within the age of minority. And your point, I thought, was, but do correct me if I'm wrong, that at a subsequent application, it could arise that the child actually had achieved minority, and one could then make these provisions work in that case.
My lord, yes.
Well, a child achieves minority by getting born. I don't understand that.
Well, it may be perhaps I'm thinking at it with Scottish language, because we regard children under a certain age as pupils and not minors. But so is minority is from the date of birth, is it? I don't know.
Well,
I think the only qualification to minor is that you are not aged over whatever it is. What is it, 18, I suppose he's saying.
well, I suppose that's right, my lord.
Right, I see.
Yes.
Oh, well, but I suppose there could be no children
Well, there could be no children.
at all.
Yes. But, I think my Lord Walker's point is that for so long as an expulsion measure against them or their parents is not actually enforced.
I mean, it may be in the great scheme of things that very little turns on this point, but I do find it difficult to accept your interpretation of that.
My Lord, so be it. So,
I think you don't deal with this in your written case.
I beg your lordship.
You don't deal with this in your
I don't deal with the particular point which
No.
has been made by my Lord Walker. My Lord, on Article 6, and just briefly to explain the way in which it works domestically. And your lordships will note that in the... would your lordships give me one moment, please? Yes, and this is basically for your lordship's information. It's at tab 101 of the supplemental bundle, and it contains chapter 60 of the enforcement guide. Would your lordships give me one moment, please? I'm grateful, my lords. My lords, it's just by way of information, so your lordships have before you how the Home Secretary would actually affect removals, and at section 2, pages 4 and 5, that's the information in relation to that.
I see.
The short point to make about Article 6 is in Article 6.2, which states that member states may exclude application of this article when the asylum seeker is in detention and during the examination of an application for asylum made at the border or within the context of procedure. So the relevance of that is to the 3 days in Article 6.1, so that it means that generally, as I understand it, when failed asylum seekers are going to be deported, they are placed in detention, and if at that stage, with a view to, deported is the wrong word, it should be removals. Since the 1999 Act, deportation is generally used only in the criminal context. But if the individual is to be removed after a failed asylum application, then the Secretary of State will, as a matter of course, ordinarily take that person into detention. And if the person is in detention and tries to and makes another application, then Article 6.1 doesn't apply, so that the individual would not have to be given the documentation within 3 days. I think the position would revert to 15 days in relation to the previous information in Article 5. So, my lords, we'd have this position. There is a person is a failed asylum seeker, is taken into detention with a view to their removal. They have to be given a period of notice, at least 72 hours notice, which the last 24 must include a working day. They may make further applications through a lawyer, and those sitting behind me have a lot of evening experience applying to the Deputy Judge in the High Court to deal with out-of-hours applications. And if the application for a stay fails, then the person is removed, and no question of having to apply. Article 6 comes into play. If the application to remain succeeds and the person, for instance, makes a further application for asylum, then the procedures would continue in the ordinary way. My lords, I now turn to the question of the word reception. And my lord,
is this your written case at page or paragraph 158? or 162, I think it is, 161, 162.
Well, that's right, my lord. And so we set out what we say there. We say that the Secretary of State has gone for a narrow definition when, if you look at the Oxford Dictionary, which I needn't take your lordships to, there's a much wider meaning set out, which is more consistent with the actual provisions of the Reception Directive. So, and that's set out in our case state between paragraphs 160 to 163. But, my lords, that is not really the key point here. The key point here is this. The Court of Appeal took the narrow definition of reception as given by the Secretary of State and applied that and put that narrow definition into the scales and found the scales of interpretation and found that it was grossly outweighed by other aids to interpretation, such as the definition, such as the way in which the Procedures Directive dealt with subsequent applications. And, my lord, also the absence of any language excluding subsequent applications from the scope of the Reception Directive. And that is clearly the way in which it was approached by the Court of Appeal, as we can see in their final section headed conclusions, where they go through the various things. And so, my lord, the question of other language versions is really a red herring. Why? Because this was not a case where the Secretary of State was saying that there was any difference between their narrow interpretation of the word reception and that in the other language versions. They were saying it was the same. The Court of Appeal effectively said that we will look at it, we think that's your best point, the word reception, but when we put it into the scale, it is effectively outweighed by the other aids to interpretation.
Do you have any difficulty with the meaning which I understood Mr. Tam to give to the word as receiving into the asylum system? I mean, he recognised that people could come into the system after being in this country for quite some time. He wasn't suggesting, I think, this is reception in the sense of working people on arrival in the UK. He didn't adhere to that line. He said that it would mean receiving into the system whenever that occurred. Does that trouble you?
My lord, it troubles me greatly, right, because when we look at the provisions, the operative provisions, we see a significant number of them are not about being received into the system, but that they may arise some years after receipt, if one wants to put it that way, or having been received into the system. So, for instance, let's just take one which is very apposite. Article 11. That sets out the benefits under Article 11 cannot begin to come into play until at least a year has run. So at least a year must have passed. So that's not, for instance, about being received into the system. It's something which happens later.
I'm terribly sorry. I don't quite follow that. I mean, 11 simply says if you don't take a decision, with a first instance decision within a year of the application, then you're entitled to work. I mean, it seems to me you've got lots of good points. I'm not sure that's one of them.
Well, my lords, perhaps I can develop it in this way. Article 11, under Article 11, the person would have been received into the system at least a year before they could rely upon the provisions of Article 11. And in those circumstances, that provision is not about what happens at the moment they're received into the system.
Well, forgive me, Article 11 works both ways, and 11.1 applies from the moment that you apply for asylum, doesn't it?
My lord, yes.
The state is obliged to provide a period unspecified during which you don't have access to the labour market.
My lord, yes. But then Article 2, 11.2, provides a benefit after at least a year has passed.
I understand that.
Right. So, my Lord, yes, I do take that point by way of qualification. But there are other provisions, for instance, in relation to medical care. That's not something which is applied immediately, but may arise from time to time. Or vocational training is something which may arise at any time during a person's residence in this country. And there are other provisions which we have set out in our case which deal with it.
Article 13.1 has a bearing on this, does it? Member States shall ensure that material reception conditions are available to applicants when they make their application for asylum. And I would have thought that fits in with the general idea that reception means entry into the asylum system.
My Lord, yes, that may be so, but in relation to that matter. But I would submit that it will relate to an existing application for asylum as well, because if we bear in mind that if the first application fails, that person then is no longer an asylum seeker and is simply a third country national.
Yes?
So, my Lord, with regards to the question of general principles of community law, the way in which we put our submission is this. This is a very clear case that there is no necessity for the court to have recourse to the general principles of community law to resolve the issue in this case. However, if the court did consider those principles, it would find that those principles are also confirmatory of the correctness of the Court of Appeal's interpretation. We set out our position in relation to that in our written case, but I don't propose to take up time and take your lordships through it now. My Lords, I come then to our summary, and we make these points. First, the definition article of the Reception Directive is clear and precise. The definitions are determinative. They should be applied. The Secretary of State now concedes that the Court of Appeal have made the correct literal interpretation. Second, the Procedures Directive treats a subsequent application as an application for asylum. The Secretary of State was, in the words of the Court of Appeal, forced to concede that this was so in the Court of Appeal. The Procedures Directive provides the most powerful confirmatory evidence as to the correctness of the Court of Appeal's interpretation. The Secretary of State's argument that the Court of Appeal should not have given it any weight is wrong in principle, and as we said, contrary to authority that we've looked at this morning. European Union jurisprudence requires a court to have regard to the state of community law at the date the provision in question is to be applied. Third, there is no language in the Reception Directive which excludes a subsequent application from its scope. My learned junior has carried out an exercise in counting up the number of times certain expressions are used, such as application for asylum is used 17 times. An application for asylum is used 9 times. The application for asylum is used 4 times. On none of those occasions is there the adjective first put in front of the term application for asylum.
Just in that connection, it may be worth noticing that there is a difference between the definition of application for asylum between the Reception Directive and the Procedures Directive, which you may have picked up. In the Receptions Directive, if we look at the definition in Article 2b, it says the application shall mean the application, whereas in the Procedure Directive it means an application.
Yes.
Now, I don't know whether that matters very much. It's rather odd that in the original draft, which I have, the indefinite article was used, and quite why the definite article has come in is not clear to me, but one should note that the definite article is used.
Yes, my Lord, and in relation to that, we say that that's simply, that the there in the reception directive definition simply identifies the type or kind of application. And that point is borne out when one looks at the rest of Article 2b, because, my Lord, looking at it now, shall mean the application, right, which can be understood as a request for international protection from a member state under the Geneva Convention. Then in the second sentence, any application for international protection is presumed to be an application for asylum unless a third country national or a stateless person explicitly requests another kind of protection that can be applied for separately. We believe that the other kind of protection, for instance, might be humanitarian protection. So a person might apply under Article 3 or Article 8 if they've married whilst being in this country and might seek humanitarian protection there. Or there might indeed be reliance upon the principle of non-refoulement in international law, which might be outside the political asylum which has been sought here. So, my Lords, the application which can be understood as is dealing with the type of application for international protection.
I mean, sorry, I follow all that, but why have you got a different word in the... You can say either will do.
Either would do, my Lord.
Very good. Yeah.
So, my Lord, none of the 30 references that I've just referred to variety of references to application for asylum, there are 30 in all, none of them are qualified by the adjective first. And the fourth point is that, on the contrary, the preamble, the purpose in Article 1, the definitions in Article 2, the scope in Article 3, and the operative provisions of the Reception Directive, we submit, are consistent with the term application for asylum applying to a subsequent application. My Lord, as we noted yesterday, we say that there are two particular provisions which demonstrate that subsequent applications are within the scope of the directive. The first one was the implicit reference in Article 16.1, third tier, to two applications for asylum, the second of which must be a subsequent application. And, my Lord, there is the explicit reference in Article 11.2 to a decision at first instance having not been taken. We know from the Procedures Directive that procedures at first instance include subsequent applications under Article 32. They include subsequent applications under Article 23.4. And they include 4H, and they include subsequent applications which are held to be or deemed ruled inadmissible under Article 25.2F, where identical applications have been put in. Those are all procedures at first instance. 11.2 then is referring to first instance decision which by definition or which by necessity includes procedures in relation to subsequent applications. Fifth, my Lords, the Court of Appeal gave weight to the narrow meaning the Secretary of State sought to give to the word reception and found that meaning wanting when put in the scales of interpretation against the powerful factors which weighed the other way. and I have mentioned those already this morning. My Lords, sixth, the Secretary of State's case was considered by the Court of Appeal at its highest level on the question of reception. So there would be absolutely nothing to be obtained by acquiring linguistic evidence now from other member states. The Court of Appeal dealt with it on the basis as suggested by the Secretary of State. The other point is this, in relation to Article 169 that my learned friend referred to yesterday. All we were doing in that paragraph was saying that the Secretary of State had not put any evidence before the Court of Appeal as to other linguistic language versions. So it was, how could the Court of Appeal properly be criticised for not making a ruling in relation to them? But as I've indicated, the Court of Appeal did better than that. It took the Secretary of State's narrow interpretation and applied it in the context of the weighing, balancing exercise it was concerned with. And, my Lords, simply put, I should just say that on the question of abuse, my Lord, that it is not common ground suggested by Mr. Tam yesterday that abuse as a generic concept is a recognised mode of interpreting EU legislation. He has not presented any authority to support the proposition. Our position is rather different. Simply put, on abuse, we say all the measures that are required by the Secretary of State to deal with abuse are set out in the Procedures Directive, and he, for reasons best known to himself, has chosen not to implement them. By way of conclusion then, my Lords, we say that we submit that what the Secretary of State's position really comes to is this. My Lords, if your Lordships look at Article 2b and look at the term at the beginning of the second sentence, any application for international protection, the Secretary of State is asking this court to remove the word any and replace it with the words the first. He's also asking this court to do the same in respect of Article 2, where it's Article 2c, where it refers to a third country national or stateless person who has made an application for asylum, to remove the word an and replace it with the words the first. And he would urge you to carry out the same exercise with regards to an understanding of the purpose in Article 1, similar exercise, Article 1 and Article 3 with the scope. My Lords, this would not amount to an interpretation of the legislative text. It would amount to a gross violation of it. A previous attempt to run such an argument before the European Court of Justice has been roundly dismissed. And, my Lords, if there's authority for that proposition, and, my Lords, it is the case of Hout Zolampt, pardon my pronunciation, on that, as with Tampere yesterday that I referred to. It's at Authorities tab 76. And
which volume?
Volume 5, I'm grateful to my friend. Volume 5, my Lord. And for current purposes, your Lordships may simply wish to note the point of principle dealt with at Article 32. where it states that whatever the reasons which might be put forward for requiring, as the French, Netherlands and Finnish governments and the Commission have done, objective proof of the place where an offence was committed, the court is not entitled to assume the role of the community legislature and interpret a provision in a manner contrary to its express wording. It is for the Commission to submit proposals for appropriate legislative amendments to that end. And, my Lords, that decision also informs us as to why a referral to the Court of Justice would be wholly inappropriate. When tasked with the interpretation of a piece of European Union text, the duty of the Court is to interpret the law, not to make it. It is evident in our respectful submission that the European Court would give exactly the same answer to the question raised in this appeal as did the Court of Appeal. And in the words of Lord Bingham, dealing with the principles underlying a reference, this Court can with complete confidence itself determine this issue. My Lords, we end with this, that intuitively the Secretary of State's interpretation just seems wrong. Legally, it is. My Lords, the appeal should be dismissed. My Lords, unless I can assist your Lordships further, those are my submissions.
Thank you very much. Mr. Nathan, do you wish to add anything?
No, thank you.
Thank you.
Yes, certainly. Do you want to move to the middle?
Now, Mr. Fordham, I notice in your written case, paragraph 18, that you say that you're in a position gratefully to adopt what has been said on behalf of the respondent ZO, and I just wonder whether there's anything really you need to add on the detail of the directives, which we've looked at with some care over the last day and a half.
What I'm in a position to do, if it would help you, is to look at the 4 so-called anomalies that Mr. Tam looked at, because there are further provisions that I submit assist in relation to each of those, and also to look if it would assist you to Article 16, because that's the closest you get to abuse. And there are some submissions I'd like to make as to why what you've heard on that is right, but again, it's supported by some provisions that you haven't yet seen. Can I take a few minutes, and if I'm not helping, I will stop.
So are we to look at Articles 5, 6, 9 and 10, which were the ones that
yes.
Mr. Tam directed us to?
I'd like to look at those and 16.
Right.
Can I just, first of all, make clear that we too apply for anonymity to continue on the basis of risks on return, and the reference is Appendix Part 2, pages 434 to 435. The starting point, and then I'll go to those provisions.
I mean, these people were all named at first instance.
They were. That's right. The starting point, a point that's not yet been made, though it's clear, which is that there's nothing new in the recognition that the Geneva Convention protects someone who's made an asylum application which has been finally disposed of and then makes a subsequent application. Whether that's an abuse depends on whether it's well-founded. If it is well-founded, it is protected by the Refugee Convention. And that's why I submit it's no surprise that these directives don't treat as abusive the mere making of a subsequent application for asylum. That's not an act of itself which is in any way reprehensible. If things have changed in your home country and you now have a well-founded fear of persecution, you're protected by the Refugee Convention, and you should make
I'm terribly sorry, are we on anonymity or have we moved off it?
No, I've moved off anonymity.
Oh, I thought you were asking us to look at page 434.
No, I simply was giving my lords
putting it
the
very
reference.
shortly, Mr. Fordham, I think the argument is, but correct me if I'm wrong, that there is an example of a previous failed asylum seeker from Burma who was sent back, and he was sentenced to 7 years imprisonment, reduced to 5 years, I think, for claiming asylum. And is it the suggestion that the regime there is such that if they know that you're an asylum seeker who's been returned, you're liable to be imprisoned under the measure referred to?
That is precisely the point. It was in total 19 years imprisonment when the Swiss authorities sent back that individual. So it's not that we would wish to have confidentiality. It's based on the risks of someone like this individual being returned. I apologise, my lord, I had moved from anonymity. That's the basis on which we...
Why wasn't anonymity sought at first instance?
I can't answer that question, my lord.
Why, as a matter of interest? I mean,
it ought to.
Why? No. Why, as a matter of interest, is Mr. Wilson not now, as he was at both other courts, representing both these appellants? Why have you sort of switched horses?
My lord, we had a number of issues to deal with between us. There was a late development in relation to T, who has disappeared, but Mr. Wilson wished, and we were happy to do this, in the light of the imminent hearing in this...
So you're dropping your voice, rather?
It was to allow continuity in relation to the arguments that were going to be ventilated before the court, and that was felt to be prejudiced by not having both teams before the court as they were before the Court of Appeal. That's the answer.
Well, it does suggest that on the argument which you're going to be developing, which is really common to what Mr. Wilson has been submitting, you should be very brief, really.
Of course, my lords, accept that, and I will. Can I then deal with those provisions? The first thing to show you is the Procedures Directive, tab 49 in Bundle 4. And if you turn to Article 10 in the Procedures Directive, 10.1a is a duty to provide information about procedure and rights and obligations. And the point we make is that Mr. Tam cannot sustain the argument that that makes sense only if you're going into the asylum system for the first time. And that is clear because when one looks at Article 34, which is specifically dealing with a subsequent application, the legislative policy is that those guarantees are to be provided. You have to do it again. My submission is that that assists when you're considering his argument on Article 5 of the Reception Directive. Because his submission was that it wouldn't make sense to be required to provide information again. It's perfectly sensible legislative policy, and it is the legislative policy of these measures. So that's the first point. That's all I want to add in relation to Article 5. In relation to Article 6, simply wanted to add that Article 7 of the Procedures Directive strongly reinforces the need for the document referred to in Article 6 of the Reception Directive, precisely because you are not removable from the time of the second application unless and until you've been screened out under 7.2. And as my Lord Kerr put it in submissions, that is reinforced by the fact that the Procedures Directive does not contain any requirement for a document for someone who is in that position. They're not removable because of their subsequent application. Why doesn't it? Because Article 6 of the Reception Directive has already dealt with that.
So it's reinforced by
the absence of a document requirement
I
in the
see.
Procedures Directive. That was the point that was made that I wished to pick up.
Yes, thank you. So reading the two together, you get your documents under the Reception Directive,
Exactly.
which fits with this provision in the Procedure
Fit
Directive.
perfectly together with it. The next provision was Article 9, but there's nothing inapt about the power of medical screening. Suppose you're going to put the subsequent applicant, could be many years later, into an accommodation centre rather than a private residence. Or even because you've got to provide the health care under Article 15. So that's 3 of the 4 so-called anomalies. The fourth is simply, if I may, to pick up the education point. Because I would accept that you're already covered once the child is in education until the time where expulsion comes to be enforced. But my response would be, so what? That does not in any way undermine the submissions that have been made when you remember that postponement of access for 3 months is plainly referable to the first time you go into education. And that's leaving aside the questions of whether the children are old enough, or indeed whether any children have been born at the time you made the first application for asylum. So those were the 4, and those were the additional points to seek to assist. My Lords, in relation to Article 16, and this of course reflects Recital 12 and abuse,
Yes.
the point I wish to pick up is that all 3 of the actions in 16(1)(a) are actions which are inherently unsatisfactory for an asylum seeker to undertake. That's why they can be characterised as abuse. But the reason we agree that this is talking about an extant application and something that I do as an asylum seeker, while I've already got an application on foot, is this: the language, my Lords, see at Article 16(1) is reduce or withdraw. It's talking about someone who's on benefit. Why are they on benefit? Because they've got an extant application. And one can contrast that language with 16(2), which is about refuse. And so 16(1) is quite deliberately talking about someone who has an extant application and has the benefits of the Reception Directive, and during that period then does something. Why are they inherently unsatisfactory? Well, the first, my Lords, is absconding. It's abandoning your designated residence. The cross-reference, which I think you haven't seen, is Article 7(4) of the Reception Directive. If you would like to write in the margin that the first bullet point is reflected by Article 7(4) of this same directive. You can be required to stay in a particular residence. And that's why it smacks of abuse for someone to go underground, as it were, or abscond. The second indent, similarly, is something inherently unsatisfactory because you're not complying with a duty that's been imposed on you. May I give you the cross-reference without turning it up to a provision I think you haven't seen, which is the Procedures Directive, Article 11, paragraph 2, you'll see is describing that kind of obligation. And of course, prior to the Procedures Directive, it would have been for the Member States simply to have their own provisions. The third indent is then talking about the situation where instead of...
Sorry, can I just
Yes,
catch you there? Just on the point of taking these two directives together, is there any reference to reporting duties in the reception directive? Or is this an indication that it was anticipated that one would understand that phrase by looking at the Procedures Directive?
I think, my Lord, the answer is that there is no reference to reporting duties or information or interviews. But if you read on, it's talking about national law.
Yes.
And as at the time when this directive first came in, I think I'm right in saying in response that those would be matters for national law.
Right.
But they were certainly envisaged, as we know, in the Procedures Directive and came to be made in the Procedures Directive.
Thank you.
But you've got action which on the face of it is inherently unsatisfactory. Similarly, the third indent, which we agree is talking about someone who's got the vehicle of an asylum application on foot and makes another one, is that, again, under national law and in due course under the scheme of these directives, one is to use the vehicle of the extant asylum application to make all your arguments. May I just give you another cross-reference that you haven't yet seen, without turning it up? In the Qualification Directive at Article 4.1, that is reinforced.
4.1?
4, paragraph 1. It's also to be found in the Procedures Directive at Article 10, paragraph 1, paragraph A.
As regards Lord Hope's question a moment ago, I think 7.6 touches, although rather briefly, on providing information, doesn't it? 7.6 of the Reception Directive.
Yes, it would. It would be, it's not designated place of residence, it would be your own chosen place of residence, but my Lord is right, it would be an example of providing information.
Yes.
I agree.
So it's 10.1a in the guarantees version, is it?
Yes, my Lord. And one has the link to this because Article 10.1a, without, I hope, unduly taking time, you've got to be told of the procedure to be followed, and you've got to be told of the means at your disposal for fulfilling your obligation to submit the elements referred to in Article 4 of the Qualification Directive. So what the state will say to you is, you use your asylum application to put forward all your arguments and all your documents in support of your claim. And that's the way that refugee protection works. That's why it's inherently unsatisfactory for someone to choose not to use an existing application, but whether with a different identity or not, to mount a second application. So, my Lord, in our submission, that explains the language of reduce or withdraw. It explains why these could be seen as suggestive of abuse from the recital, but it is to be contrasted with the mere fact of lodging an application once your previous one has been finally determined. You haven't got an existing vehicle there. And so the proper way to proceed, if there's a coup in your home country and you are now a refugee, the proper thing to do is to make a subsequent application. And there's nothing abusive about that. Unless and until you look at the merits and either decide it's inadmissible because it's identical or it's indistinct and therefore doesn't need to be further examined, and you've got the submissions about that. That's dealt with by enabling the state to make its final decision, and then you have no right to stay and then you have no reception rights at all. So for those reasons, I hope it's been of some assistance to revisit very briefly those articles. Unless you've got any questions for me, that's all I wanted to do.
Well, only this. I mean, I think in your written argument you do take the point that unless you're right, then for what may very well be entirely bona fide second applications, surplus, change of situation in home country, etc., which may take years to determine. On the Permanent Secretary of State's case, a lot of the other benefits under the reception directive lapse, which is your, so to speak, which will give me just two good ones from your point of view.
Yes, when we're looking at the minimum standards,
Yeah.
Articles 8, 13.2 and 15.1. I realise that's 3.
Sorry.
Article 8,
Well, 8 were...
family unity. 13.2, reception conditions to ensure subsistence level welfare.
And 15.
And 15.1, necessary health care.
Yes.
It makes no sense. And recitals 8 and 9, which 7 and 8, which I don't think have specifically been referred to, strongly reinforce this. You are talking about minimum standards to ensure a dignified standard of living, and you are harmonising so people don't leave because they can get a better deal somewhere else. All of that is plainly as relevant the second time around. So I would have no problem, in answer to my Lord Hope's question about entering the asylum system, receiving into the asylum system, providing two things are recognised. One is you stay in there until the final determination, but that's in the definition. And the second is you are received back into the asylum system. The second time around, can I just ask you to note that there are exceptions to the scope in Article 3?
There are what?
Exceptions. The draftsman was perfectly able to include exceptions. See Article 3.2, and I think, again, you haven't yet seen these, 3.3. And in fact, the Displaced Persons Directive, which you've now got in the latest bundle, is a good example. You go through the system of
Is it
special...
sorry, Mr.
Three-
Ford, is it 3.3?
3, Article 3, paragraph 3.
Yes, not 3.2.
Well, 3.2 is an
3.2 is
exception,
another exception.
Oh, I see, yes.
and 3.3 is an exception.
Yes, I see, yes.
So the draftsman thought about the sort of situations
Yeah.
that were to be excluded. And in fact, that second situation is quite a revealing one, because you go into a protective system in the EU asylum scheme for 2 years as a specially protected person. You come out of the other end and can claim asylum, and Mr. Tam would accept that in that situation you would be within even his definition of reception. My Lords, I'll resist the temptation to say any more unless there are any further questions.
No, thank you very much. Mr. Jacobs?
No, my lord.
Thank you. Mr. Tam?
Please, your lordships, keeping this as brief as I reasonably can I start with a few points of essentially of information following on from questions I was asked yesterday. First of all, it's important to make the point that...
Important to do what?
Make the point that the CRD Case Resolution Directorate backlog, which is the backlog in which these respondents find themselves, is one which is essentially a closed pool. because it is dealing with the case records that were identified in certain situations and trying to get rid of them, resolve them and finish them. There was in parallel a new asylum model set up. I think that's actually a term of art in addition to the descriptive force of that. And that is what I referred to yesterday as a system in which there's a target for the majority or vast majority of cases to be fully resolved within 6 months. And I think that that's intended to include removal. So there are the two systems working in parallel. It is not the case that people who come in now will find themselves ultimately in the Case Resolution Directorate backlog. That is intended to come to an end when they have dealt with the backlogs that they are dealing with now. There is
when did the new parallel system come in?
I think it was also set up in 2006. I was going to take you, in fact, to the paragraphs in the witness statement that deal with it. If you could go to, please, to Appendix 1, page 68.
The new asylum model.
The new asylum model, yes. So at the same time as the creation of CRD, sorry, this is in the spring of 2007. You see the dates at the beginning of paragraph 28 there, with the target that by the end of 2011, that 90% of new asylum cases should be either granted or removed from the UK. In terms of the actual performance of the Case Resolution Directorate, there have been variations of the rates at which cases were being concluded at different times. As one would expect, there was a ramp-up period, and then there has been learning as the process has gone on. If you go on to paragraph 40 of the witness statement on page 71, you'll see a reference to a National Audit Office report, which is actually copied, quite a substantial document starting at page 114. I won't go to that because I just need the extracts from that. You see the description there in the quote at paragraph 40. At paragraph 41, there's a reference to data problems. And then at the quotation of paragraph 5.8, you see that 335,000 cases were allocated to case owners in December 2007. And then there was a forecast of the rate which CRD expected to conclude cases, and that the current plans, at the end of that paragraph, you see, were for a conclusion of, on average, some 6,700 per month between now and 2011. The now is January 2009. The Permanent Secretary wrote to the Chairman of the Public Accounts Committee, you see this at paragraph 42, and you see the statistics given there in the last paragraph of the quotation, that in the latter half of 2008 we concluded an average of 10,000 legacy cases per month, and we have already cleared 155,000 cases to date. So we are talking about very substantial numbers here. I have asked for some information about the rate at which cases are currently being dealt with. This has to be given with a caveat that this is taken from management information, which is current and up to date, but may not be of the same standard as the national statistics would like. So if they are produced into official statistics, there may be some variation. But at the moment, CRD is concluding some 3,000 cases per week. In the course of that, CRD is currently receiving about 600 sets of further submissions every week.
About how many?
600 per week. And those, of course, have to be dealt with in the course of concluding those cases.
Not necessarily in respect of 600 persons. I mean, could it be that there are several from one individual in the week?
There might be, and I wouldn't want to assert that they will necessarily be in relation to 600 different people. Although I would imagine that there could be few cases where the individual will make more than one set of further submissions every week. But a case may have several sets of further submissions made during the course of its life, and that is something that is.
So this 3,000 a week and this 600 a week, I mean, this is all in this backlog, within the backlog.
It is all within the backlog, yes. And
the backlog became a closed figure at what point?
I don't know, because the work of the CRD has changed its shape from time to time as time has gone on. But it is dealing with established backlogs and not with new cases.
Well, I think actually paragraph 28, it does say the CRD system doesn't deal with new applications lodged after 5th March 2007.
That is right.
Is that right? Does that close the class?
It does. That does put a limit on the a date limit on new cases coming in that won't end up in CRD. But the exact composition of the CRD workload hasn't been exactly static through time. I wouldn't want to give a misleading answer about
these 600 further submissions a week. You say they're all in respect to the backlog. So I mean, there may be further submissions coming in respect of asylum applications which were lodged after this March 07 date, and indeed finally decided cases.
No, the 600 per week figure relates only to cases which are in CRD.
Okay.
By way of contrast, I've been provided with some figures in relation to the new asylum model. The current intake of new asylum applications is somewhere in the region of 350 or 360 per week. That's new applications for asylum.
By new, you mean first time, do you?
First time.
Yeah.
And those are dealt with by or in the new asylum model. And the new asylum model teams currently receive about 60 sets of further submissions.
60
sets of further submissions per week. There's another pair of figures which may also assist to give a feel for the size of the problem. When the CRD was set up, some sampling work was done to try to gauge the extent of the work and the resources necessary to clear the backlog. And one of the things looked at was how many cases going into the CRD backlog had further submissions made. And the figure was estimated to be somewhere between 20 and 30%.
I'm sorry, 20-30% of what?
Of the cases going into the CRD backlog were cases on which further submissions had been made. And another thing that has been looked at is the percentage of those further submissions which are ultimately seen to meet the test for a fresh claim. And that figure is something like 20 to 30% of the further submissions.
So that's 20 to 30% of the 20 to 30%.
Yes, are further submissions that meet the test for a fresh claim. Or to put it another way, of the further submissions that are made, 70 to 80% are not fresh claims.
I mean, what I don't have any view for is what of the further submissions, what proportion does the Secretary of State accept as not as fresh claims, but grant leave, right? Or grant. It's always asylum, is it, or could it be indefinite leave?
Well, it may be a number of things. DT, for example, was granted indefinite leave to remain, but I don't know on exactly what basis.
Well, but what proportion are granted whatever they're basically wanting, and what proportion, although they're refused that, are nevertheless accepted as fresh claims so that they attract appeal rights?
Yes, that figure I don't have, because if a claim meets the test for a fresh claim, then it may well be granted. Of course
it may be, yes. But it isn't a fresh claim actually, unless it's been rejected. I mean, if you actually look at 353, if it's going to be accepted, you don't look at whether it's a fresh claim. If you actually look at the language of 353, it's only if rejected will then determine whether they amount to a fresh claim.
Indeed.
And fresh claim is defined in terms notwithstanding its rejection.
Yes. I'm not saying that, that of the decisions that are made, 20 to 30% are rejected but found to be fresh claims. That the words that I've given appear to be deliberately formulated, that they don't appear to meet the test for a fresh claim. So just looking at the range of further submissions, and you ask yourself how many of these further submissions, before we've made any decisions on them, how many of them appear to meet the test for being a fresh claim? And the answer is 20 to 30%.
I'm not sure I follow this. I thought that if they do meet the test, then there's a duty, as it were, to certify them as meeting the test, and then the individual takes his luck.
Lord, these numbers are not being taken from decision making. They're being taken from management sampling to try to understand what the composition is of the work that needs to be done.
Yes, I see.
And so it's not looking at the question of how many decisions have been made, how many have been rejected, how many have been recognised as fresh claims.
So these are cases, as it were, that are held in the system and goes through them to see what the nature is of each particular case.
Lord, yes.
Yeah,
yes. So looking on that sampling basis,
yes.
Looking at them, it looks like 70 to 80% of further submissions would not even meet the test for a fresh claim, and only the remainder would. How each of them is then dealt with when they come up for decision will, of course, be a different matter. So that is, as a matter of numbers, I hope some flavour of what or how the decision might affect the further, or give a size of the numbers of cases that this decision might affect. Lords, I also rather rashly undertook to try to produce some note about whether and in what circumstances further decisions have to be made once an asylum claim is rejected. When we discussed this, it turned out that might turn out to be a small textbook rather than just a note. Can I perhaps...
I'm sorry. I mean, at the moment, as the Secretary said, operates these things, when there's a finally determined first claim and in comes a second claim and it's waiting for some years for the way you look at your 253 cases, fresh claim cases, okay? I mean, what actually on the ground happens, I mean, it's obvious in this case that in terms of you don't give employment permission, but what do you do in the way of these various benefits? I mean, do you cease all benefits?
No. And this is the point that I made yesterday.
That's why I want to know what practical effect of your...
Right. In practical terms, what happens when an asylum seeker's, a first-time round asylum seeker's application has been finally determined against him, is that he comes... perhaps I should start from the beginning. Somebody who is clearly a first-time round asylum seeker is eligible for support from the National Asylum Support Service, or NAS, under Section 95 of the 1999 Act. When his asylum application is finally determined against him, he will cease to be eligible for that, but he becomes eligible for support under Section 4 of the 1999 Act, And that eligibility continues right up until the time that he is removed from the country. So this is not a case of individuals being left without anything if the reception directive does not apply to them. There are perfectly...
I mean, well, we had all this yesterday. I appreciate that the UK does better than, on your submission, subject to human rights obligations, it needs to do under the directive. But, I mean, I don't know what the Section 4... I mean, are they worse off than if they were under NAS, under Section 95?
It is not as good as Section 95 support.
I see.
Yes.
Section 4 of the same Act?
Of the same Act, 1999 Act.
Robin, it's paragraph 74 of her witness statement.
Sorry?
Paragraph 74 of the witness statement.
I'm grateful. Learned Friend has found the paragraph in the witness statement that sets this out.
Oh, good. Oh, well,
Paragraph 74.
74?
Yes.
Yes, referring to Section 4 support.
That's right. So that's Section 4 of the 1999 Act.
I see.
Yes.
So, as I said, it's far from being the case that they would be left bereft. The reception
Well, I follow that,
directive...
but I mean, you're telling us, so to speak, the scale of the consequences of all this, but I mean, I'm just seeing, you know, what about Article 15? Healthcare presumably doesn't change, or does it?
Yes, because there are certain types of healthcare that are available to anyone, and
But is it reduced healthcare if you've lost out on your first asylum claim?
I'm not sure of the exact impact on the provision of healthcare, but certainly the failed asylum seeker continues to have access.
Well, I'm sure he has
essential healthcare as.
But you don't know if it's the same or if it's lesser.
I'd have to take specific instructions on that.
And the other one, Mr. What's his name? Fordham mentioned was Article 8, families. Is there any change as to how that is applied?
Again, the exact impact of an obligation under Article 8, we would have to look at, or I would have to ask for specific instructions on.
Well, it's most unlikely that the healthcare will change in terms of Article 15, because Article 15(1) provides that member states shall ensure that applicants receive the necessary healthcare, which shall include at least emergency care and essential treatment of illness. Indeed. So it's highly unlikely that while there may be a change in practical terms, it's unlikely to fall below that standard.
That's right.
It's unlikely to fall below that standard, and I suspect that our domestic courts, including this court, would not tolerate it if failed asylum seekers weren't provided with at least essential healthcare. So that is why I said yesterday that it is notable that this question of interpretation has actually arisen in the context of a permission to work application, and has arisen so many years after the directive came into force and its provisions were transposed into our domestic legislation. But it doesn't alter the fact that the interpretation of the directive is it's an issue which is capable not only of affecting the asylum seekers who we have within the UK, but asylum seekers across the whole of the community. And other states may well have more difficulty or may find it necessary to make more adjustments if your Lordship's decision is that this directive clearly and beyond doubt applies to the second time round asylum seeker in the same way as to the first time round asylum seeker.
Perhaps prudently, you didn't refer to Article 15 because it seems to me that given the obligations of members of the EU to member states of the European Union to comply with minimum standards under the ECHR, that Article 15 cannot be of any considerable significance in any member state.
Indeed, the ECHR provides at least some protection for all of these individuals. And that is why we make the point that the reception directive is not the be-all and end-all of this. It is.
I was making a rather different point, but you're not to be blamed for going back to one of yours, I suppose.
Could I be quite clear, Mr. Tam, that what we have in Volume 1, Tab 6, contains the provisions that you've mentioned. Tab 6 appears to be extracts from the 1999 Act, and we can see on the second page of the extract, Section 4.
Which Act is?
It's Tab 6.
Indeed.
And it's the 1999 Act.
Yeah.
To the Acts. And Section 4, and then a few pages on, we get Section 95. Those are the two provisions.
Yes, those are the provisions that I'm referring to.
I mean, 95 is expressly providing for support to asylum seekers or dependents who appear to be destitute, whereas Section 4 is pretty sparse. It's just talking about arranging for accommodation, but is that taken to be more than just a roof over their heads?
Yes, because the way in which it's provided, if I understand it correctly, includes vouchers for food and so on. But that's the power that is being used to provide this support.
That they don't qualify under Section 95 once their first application has been rejected.
That's right.
Finally disposed of.
Yes, that's right.
I don't want to complicate this, but asylum seekers, is that the business where it's all defined under this legislation that they've got to do it at the port of entry or within a reasonable time there? Is it all that lot of cases?
I can't remember if that's in this Act, but certainly the asylum seeker as used in this Act refers to people whose claims have not yet been determined. So once it's been finally determined, they cease to be an asylum seeker for the purposes of this Act.
Cases like Limbuela, I mean, didn't we have to deal with those who somehow, I can't know why they weren't asylum seekers, because they've been ruled out on some basis. I can't remember. Wasn't it?
They either weren't or they had ceased to be asylum seekers, and the questions that arose in those cases were what were the obligations of the various bodies to provide support for those individuals to make sure that at least they didn't fall below the ECHR safety net. And Section 4 is now the means by which those people are provided with the requisite support.
My recollection is you could drop out, you could fail to be an asylum seeker because you didn't apply in time or at the right place. Is that wrong? Or
yes, or as soon as reasonably practicable.
as soon as reasonably practicable.
Yes.
But does that business still survive the reception directive?
Yes, it does, and that would be that would be permitted by, I can't remember the number of the provision in the directive that
Is that the 16.2 bit of it?
Yes, 16.2.
Is that the 16.2? So they're ruled out under 16.2. Is that it? I think that must be it.
Yes.
What?
Does look like it.
Okay. I'm just trying to sort of slot this case into a wider... Okay. Right.
But what the wider series of cases does demonstrate, we respectfully say, is the point that we make that the narrow question of interpretation of this directive is not one which either, if depending on which way the question is answered, either provides support for these failed asylum seekers who are in the backlog, or somehow leaves them completely bereft. That is not the way it's done, and there are plenty of other domestic statutory provisions and convention obligations that protect those individuals and which are properly implemented by the UK. True it is that the standards may be different. Once you've been through the asylum system once, you've had your claim rejected, and you are seeking to stave off removal by making further submissions, which possibly might be good, but are being made from a starting point that you've already had your claim rejected, including on appeal. So that's why this is not it's not an all or nothing point, and one can look at this question of interpretation with a proper, strict eye on what it was really designed to achieve and which individuals was it really designed to cover, without fearing that the consequences that those who fall outside it fall out of everything. They don't.
Well, they don't in this country, but they might do in Greece or Lithuania.
They would still be. They would still have the protection, at least, of the convention in those cases. Lords, can I then turn to reply on a handful of the legal points that were made? The first one refers to, the first one concerns the approach to interpretation and the criticism that has been made, or two criticisms that have been made of our argument. First of all, the suggestion that we are trying to in effect, amend the legislation by our argument. With respect, we are not. It is, when dealing with an international instrument, it is far from uncommon for matters, or for the instrument to be interpreted in a way that, or where the subject matter of the case falls outside the scope of the instrument, ratione materiae. It's a phrase used specifically in relation to treaties, but there's no reason why that interpretative obligation can't be applied in respect of a directive, if the directive simply wasn't intended to have that wider scope as to cover the facts of the individual case. So we are not trying to ask the court to embark on some unusual form of legislative amendment in doing this. It's a very common task and a very common approach indeed. The other suggestion that was made, in fact, actually, while I'm looking at this authority, can I perhaps just draw attention to a passage in it? I was going to ask you to go to Mr. Laysock's book, which is in volume 6 at tab 84. You see from the contents that have been copied at the beginning of the tab that this is dealing with general principles of EU law and then principles of interpretation of EU law. Can I ask you, please, to go first?
People put in the frontispiece for these things these days.
Yes, I'm sorry, I don't know why that wasn't done.
Yeah.
But can I ask to go straight on to paragraph 81, which is on page 3.209, but the page number's actually fallen off the bottom of the page. The left-hand side has a page number 3.208, and then on the right-hand side there's paragraph 81.
Sorry, I'm being slow here. Paragraph 81.
81, please.
Is this the first edition of the book, or the second, or, you know, it doesn't give much information in the index. It doesn't give the date.
Yes, I'm sorry. We can find that out. loose leaf, right. I'm told it's a loose leaf, a loose leaf work, and we can trace through the exact.
According to the index, it's Vaughan and Robertson,
Yes,
and it's a chapter
it's a chapter
by
from the
Dr.
Vaughan and
Lesop.
Robertson book.
But we're not told in the index the date or anything about it. But it's Vaughan and Robertson, Law of the European Union.
And as a loose leaf works, there'll be different dates for different sections.
Well, it's paragraph 81, aids to interpretation, is it?
Yes, aids to interpretation, the text, we draw attention from about 6-7 lines down. However, the clear meaning of a provision and its literal meaning are not synonymous. In some cases, reference to the literal meaning of the text has been sufficient to establish its true construction. It has been said that legal certainty excludes any interpretation that departs from the normal meaning of the words used, but literal analysis of the text is not always appropriate in view of the nature and scheme of the measure in question or the circumstances in which the provision was adopted. The literal meaning of a provision must be discarded if it is inconsistent with the purpose, general scheme, and the context in which it is to be applied, or where there are discrepancies between the language versions of the text of the provision. In consequence, even if the wording used seems to be clear, it is still necessary to refer to the spirit, general scheme, and context of the provision, or the practicalities of operating the provision in order to support the interpretation that flows from the words used, a fortiori if the wording is unclear. And that, we say, clearly includes a ratione materiae approach to interpretation, if that is what the scheme and the context call for. The other part of this chapter to which we ask to draw attention relates to abuse. Can I ask you to go on to page 3.242? It's very close to the end of this tab. Principle 19 of the interpretation of EU law is the possibility of abuse.
Again, I'm sorry, this is page
3.242.
It's four lines from the end of the...
what page?
It's paragraph 139, and the page number is in the very bottom left-hand corner.
Oh yes, I've got it, thank you.
I'm grateful.
Yep.
139, the scope of EU legislation cannot be extended so as to cover abuses carried out by a trader, and therefore provisions will, where possible, be construed so as to avoid opening the way to abuse. The case cited in footnote 2 there, Gloschuk, was originally an English case dealing with the EC Poland Association Agreement. So it is not confined, strictly speaking, only to trading, because that's an immigration type measure. That was, your lordships may recall that was the context in which that arose. So it's a familiar approach in domestic law, and one is unsurprised to see that in EU law as well. Hence, I hadn't thought it necessary to refer to that in opening, but seeing as we are criticised for that, there is authority, if any, is needed for that. The second point relates to interpretation in the light of subsequent measures. The three cases that my learned friend has referred to that are cited in footnote 133 of the Brent book don't establish the proposition that we say it would be necessary for the respondents to establish, which is to say that if a measure has one meaning at the date of its adoption, that meaning can be changed by the adoption of a subsequent measure later in time. And that is what we say would have to be done to the reception directive if the respondent's argument were to be accepted. What one sees in those three cases is, again, the application of principles of interpretation which are entirely familiar in the domestic context. If the whole scheme refers or takes the same approach to a particular matter, then that is something which can be referred to in confirmation, perhaps as one of the cases says. But what they don't establish is that a later measure can change the meaning of an earlier measure without there being any form of amendment of it. And it was in that context that we drew attention to the chronology of these measures. The 10-month period, of course, was the 10-month period between the deadline for transposing and the agreement of the deadline for transposing the reception directive and the agreement of the procedures directive. The difference in date between the two directives themselves is, of course, much, much bigger than that. The reception directive, January 2003, so the procedures directive actually agreed almost 3 years later, and that's a considerable period of time. One of the reasons, if one follows through the footnotes from the Commission proposals, appears to be that the Commission had to amend its proposal quite substantially because there's a second proposal referred to in the footnote to the Procedures Directive. And that was published in November 2002, one can see from the footnote, and even then it took another 3 years before the Procedures Directive was actually agreed by the Member States. So it's quite a long gestation period.
I see that in paragraph 90 at 3.216, Mr. Lassock acknowledges that preparatory material showing the legislative history of the provision may be relevant to the interpretation of the measure, either as a direct aid to construction or as an aid to identify the purpose of the measure or the provision itself. So it is legitimate. Would you accept to look back to the origins of these provisions?
Yes, in common with other international measures, that can provide interpretative clues. But none of that assists in yes, I'm grateful to Malone Jr. Draw attention to 91 as well. And there's some more at 92.
Thank you. Perhaps 92 footnote 5, the case referred to at the top of page 3.218. It says that the interpretation of a provision is not affected by material that was in the text of the measure as proposed, but was not included in the text as adopted. And I suspect that's what your junior is pointing our attention to.
Lord, yes. And of course, the negotiating documents at the beginning of paragraph 91.
Well, I mean, I think what I was looking at was not negotiating documents, it was the proposal emanating from the Commission, which is a different thing.
It was, and that there are familiar points to be made about this, that a proposal is a proposal. And if there are any differences between what's in the proposal and what's in the final instrument, there must be a reason for that. One cannot simply carry over a proposal or a text in a proposal into the meaning of the final instrument.
I don't understand the relevance of that here. I mean, that's sort of Prenn and Simmons in Luxembourg. I mean, we're not in that country, are we? We're here with a proposal which was eventually implemented and which dealt with the position. Of course it dealt with it later, but it adopted the same effective definition.
I think I would have to accept that one cannot get away from the historical facts that there was a European Council, that there was a proposal for a common European asylum system, that certain measures were proposed, and that eventually a number of measures have been adopted, including the Reception Directive and the Procedures Directive. And those are bare historical facts which it would be, I think, probably futile for me to try to ignore or sideline. But that is not the exercise which your lordships are being asked to embark on. Your lordships are being asked to compare the detail of the text of these two measures to see what meaning can be gleaned from one that affects the meaning of the other. For that, one looks at the final texts of the measures and not proposed texts which did not find their way into the final texts.
But I'm sorry, I mean, your argument is that in the Reception Directive, on the literal meaning, it includes second applications, but it's obvious from the thing as a whole that it doesn't. So there you've got a definition which the framers realised doesn't include second applications. And then lo and behold, however many years later, the same legislators deal with, use the self-same definition to manifestly include second applications. I mean, why would they do that?
Lord, it wasn't simply by using the self-same definition. As I drew attention to yesterday, what they did in the Procedures Directive was to make very specific provision for second applications.
Of course, but by definition, that means that they fall within the definition.
But that would, with respect, that would be to adopt precisely the literal approach, which is to say, well, anything that you can make fall into this definition must therefore be the subject matter of the directive every time it appears in the whole of the directive. But you can see that that's not the case, that not all of the directive applies to every application for asylum. The subsequent applications have their own article, and the articles, the permission given by the article for the speedy examinations on are then referred to in other articles in the directive. As I said, there is a bolting on of provisions for subsequent applications onto a directive which on its face largely concerns first-time round applications, as one would expect. And that is what one sees in the Procedures Directive, and one sees no trace of that at all in the Reception Directive. And that is we draw attention to that because that, we say, is an important part of understanding why the Reception Directive was framed as it is and why it does not deal with the obvious difficulties that arise if you try and adopt the literal interpretation for which the respondents contend. Lords, the third point to which I ask to draw attention is one for which I need to go into the Procedures Directive. It's Volume 4, tab 49, please. It concerns inadmissible applications, which are dealt with in Article 25 on page 326/25. It was suggested by learned friend that if the application is found to be inadmissible, it simply ceases to exist for the purposes of the Reception Directive. And we respectfully say that that cannot be right for several reasons. First of all, if you look at Article 25(1), it does use the words an application, and then at 25(2), an application for asylum, which may or may not have the quality of being inadmissible. That means that, at least on a literal reading of the directive, that it is an application for asylum, at least until it has been decided to be inadmissible.
I think that's the case that's made against you, yes.
One has to go on from there. But the first thing is that if it is an application for asylum, then the minute it is made, and it's inevitably going to take time for its admissibility to be decided, it triggers the reception directive. So that is not, we respectfully say, any answer to our point about inadmissible applications.
It would have that effect first time, wouldn't it?
Yes, it would have that effect first time, but it would have that effect second time and third time and fourth time, even if the member state can then declare it to be inadmissible within a relatively short space of time after that. So for the purposes of the reception directive, it's going to be an application for asylum on the respondent's reading. And so even inadmissible applications second time round and subsequently trigger the reception directive. The respondents could not get away from that, and we respectfully say that there is no good reason for it. But one goes on from there to Article 39.
Sorry, just before you do, I mean, on that approach, how does matters stand with these recurrent identical applications, each one having to wait till it's declared inadmissible with respect to Article 7.1 of the Procedures Directive? They still have to be allowed to stay in the country because it's all under Chapter 3.
Until it's been dealt with.
Right.
That's a matter of that would be a matter of substantive protection.
I know. But I mean, how is that abuse to be cured, do you suggest, under the Procedures Directive?
Lord, in terms of dealing substantively with the application, we accept that, of course, if submissions are made, they do have to be looked at. The individual can't simply be removed without consideration of them. So that the protection against removal is one which the member state simply has to deal with.
How do you ever get rid of somebody on this approach to to Article 25 and 7.1?
Well, ultimately, you have to throw vast resources at individual cases.
No, but how do you do it at all? I mean, assuming that every time you say this is identical, inadmissible, they by the next post, they say, well, here's another identical one. Meantime, Article 7.1 says you can't ship him out.
Well, you have to deal with it, and
how do you do it?
Well, ultimately, sometimes by rejecting it by return of facts, by rejecting the submissions by return of facts, and sometimes when the individual is literally at the airport about to be taken onto the aircraft.
Right.
But it's phenomenally expensive, phenomenally resource-consuming, and indeed that all too often includes consuming the resources of the courts in having to deal with attempts to make judicial review applications at 7, 8 o'clock in the evening, learned friends refer to the evening work. If somebody is determined to hang on in the country by any means possible, we accept the submissions have to be dealt with, but it's an extraordinary process sometimes.
Sorry, I interrupted you. We're going to 30
So
what?
Article 39, please, which provides that even a person who's made an inadmissible application has a right to an effective remedy. That's 39(1)(a)(1).
Yes. Yeah.
The individual is clearly, even if he's made an inadmissible application, so one that is so bad that it falls within that category, he still has a right to...
He can JR you and say it wasn't
Indeed.
identical after all.
But the point that we make is this: while the state obviously must accept its obligation to deal with the substantive requests for protection, to look at the submissions, to consider them, and to reject them if that is the decision, it makes no sense for every round to trigger the full panoply of reception directive benefits. If the reception directive had been drafted with a view to including that type of case as well as the conventional first-time round applicant, it would have said so. And so Learned Friend's attempts to try and sideline inadmissible applications with respect doesn't work, because on his literal reading, or their literal reading, one gets to exactly the same position.
But am I wrong, Mr. Chairman, that let's take a first-time application, which is inadmissible for the various reasons set out in 25. Even so, there is an application made, and therefore it does trigger the whole gamut of benefits.
It does. A first-time round application.
There's no way of screening them out at first instance on that ground.
Yes, and if it's a first-time round application, then clearly the individual is in a different position, because if he makes the application, then he is entitled to, perhaps one can put it like this, to one bite of the cherry. But when it's been considered and dealt with, he is then in a different position, and in a different position in all sorts of respects. The fourth point, Lords, is that the Learned Friends now accept, which they did not accept below, that Article 16(1)(a), third tier, or perhaps third indent, Junior suggests, does not provide the answer to this problem. Yeah. And that is to say, the Reception Directive does not contain any provisions against abuse. The focus has been entirely on using the Procedures Directive to stem any abuse caused by repetitive applications. That is a significant concession on their part, because we respectfully say that underlines and reinforces our point that if the Reception Directive has a scope for which they contend, but is wide open to abuse, that interpretation is problematic. And one also has to ask the hypothetical question: what if the Procedures Directive had not been agreed and the Reception Directive stood alone, as it did for a considerable period of time? What if the Member States were so unable to agree on the Procedures Directive that the anti-abuse, that is to say the speedy consideration and so on provisions of the Procedures Directive had never been agreed and they were never in there? We respectfully say that if you look at the Reception Directive alone, because it did stand alone for a period of time, it is very unsatisfactory indeed to give it an interpretation which does leave it wide open to abuse, with no anti-abuse provisions within it. Those problems simply do not exist on the Secretary of State's submission and the interpretation that we proffer. The fifth point relates to the Dublin Convention.
Nobody's made very much of that, I don't think.
We haven't had a word about it, have we?
No, sorry, I've gone into this the wrong way. Learned Friend made an observation about paragraphs 97 to 103 of our printed case. Seeking to explain why we got to where we got to here. At 97, we say we submitted that the Court of Appeal was wrong to refer to and rely on the Procedures Directive as an aid to interpretation. That is to say, as I've been trying to expand, the Procedures Directive does not help you decide what is the scope of the Reception Directive in the way that we have described it. Does it actually go further than the first-time round applicant? And the reasons why that is so includes the reasons that we set out at paragraph 98. because if you look at the way that the terms are used in the Dublin regulation, the literal reading would be contrary to the way that the Dublin regulation actually works. And that's why I wanted to show you some of the provisions of the Dublin regulation to demonstrate that point. For your Lordship's reference, our submissions on the Dublin regulation itself and our explanations to why the Court of Appeal is wrong are set out in paragraphs 55 to 66 of the printed case. But for present purposes, can I ask you to go to the regulation itself, which is in Authorities Bundle 4 at tab 50. The core of the Dublin regulation is Article 16. It's on page 50/6. And it's the obligation of the member state responsible for examining an application to take charge and take back. The previous provisions, I should say, we don't need to go through them, but they give a list of criteria for deciding which member state is the member state responsible for the application for asylum. And if you look at the circumstances here, the member state responsible for examining an application for asylum shall be obliged to take charge of an asylum seeker who's lodged an application in a different member state, B, to complete the examination of the application for asylum, C, take back, under the conditions laid down in Article 20, an applicant whose application is under examination and who's in the territory of another member state without permission, and take back an applicant who's withdrawn the application under examination and made an application in another member state, and then E, take back a third country national whose application is rejected and who's in the territory of another member state without permission. Now, the point that the Court of Appeal suggested was that if you make an application in country A and you make a second application in country A, and the first application is rejected, you then make a second application in country A, and then you go to country B and make a third application for asylum. Country A is responsible because you have made the second application in country A and it has not yet been decided. But if you look at Article 16, you can see that that is not the way that the Dublin regulation works. The Dublin regulation would oblige would oblige the member state, would oblige country A under 16(1)(e) to take back that individual because of the first application for asylum, not because of the second application for asylum. Now, on its own, that's an extraordinarily technical point, but it goes to show that in another measure in the common European asylum system, you can't apply a strictly literal reading of the words application for asylum, and you can't apply the strictly literal definition provision, which is in identical or near identical terms in Article 2. You have to look at what the regulation is actually trying to do. And on this occasion, the words application for asylum mean the first application in a country A, not the second.
Yes?
Yes. Yes. And, Lords, for further detail of that technical point, we have it in the printed case, but for present purposes, I don't need to go any further into that. Lords, there are then two final points, if I might
I was
ask.
just wondering, I mean, how much longer do you expect to be?
Less than 5 minutes.
Well, that's, yes, we'll remain.
I'm grateful. Lords, the two final points are these. Learned Friend referred to Article 11 and other articles which may either come into effect or have effect later during an asylum seeker's progress through the system. But that does not detract from the importance of the word reception and the concept of receipt in the title of the directive. Because even though they may come into effect later, they relate to entry into and then subsequent progress through the asylum system. Article 11 on employment is a case in point, as my lords point out. There is a time reference to the time at which the application for asylum is made. That is when the individual is received into the system. So these, the fact that there are continuing effects from the directive does not detract from the fact that the focus of the directive is on the concept of reception. The one thing that the concept of reception or welcome or acceptance in other languages, what they do not relate to is the position of an individual who has been through the whole system, he's failed to establish a claim, and he is now trying to stave off his removal by making further submissions as to why he should not be removed. We accept, of course, some of them may succeed in doing that, but that is the position in which they are. There is no proper use of language which could describe those people as being received or welcomed or accepted into the asylum system. If you couple that point with the difficulties in operating the reception directive's provisions for the second time round applicant, we respectfully say that the answer is clear. And thus the final point is this, that even if that your lordships find that the answer is not clear, the materials that have been placed before your lordships during the course of yesterday and today, we respectfully say amply demonstrate that there is material here which ought to be considered by the court in Luxembourg. Because the considerations that go into trying to ascertain whether the reception directive can properly be made to work in respect of second-time round asylum applicants, and what other member states might have to say about them and its effects, is something which should properly be considered by the court in Luxembourg. Yes, Lord, sorry, there is one point that Learned Junior reminds me I should have dealt with, and that is simply to point out, if you can go to the Reception Directive, Volume 4, Tab 47.
Which one? Sorry.
Volume 4, Tab
Yes,
47,
yes.
the Reception Directive, is to point out that in Article 2H, there is a definition of minors, or unaccompanied minors,
Yes.
at least, which I hope puts that point beyond doubt.
Yes.
Thank you very much. Yes. Oh, yes. I'm asked to draw your lordship's attention to something that Learned Friends have put into the supplementary bundle of authorities. It's Bundle 8, the ring binder, tab 100. It's the House of Commons Home Affairs Select Committee report of March of this year, which deals with, amongst other things, deals with the legacy cases. There are some observations about that at paragraphs 4 to 6 of the report, which is on page, yes, it is page 4. That deals with whether or not the rates will be sufficiently maintained to clear the backlog. In that context, can I please then draw attention to page evidence 24, which is towards the back of the report. It's probably about two-thirds of the way through the clip.
Sorry, page one?
It's EV 24, 24 of the evidence. In the first half of the page, there's a chart, and then there's the words performance update. And paragraph 16, halfway through, can I draw attention to the words, whereas in December, that's December 2009, we concluded on average around 1,100 cases a week. We are currently putting around 3,000 cases a week into the CRD, and this will continue to rise. That letter was dated March 2010. And I've given your lordships the information that that's the sort of current output of CRD as well. The point is that at times the amount of work that's been concluded has varied. Obviously, when it drops, it does give rise to concerns. But UKPA is confident that on current rates, it will be able to achieve the target by the summer of 2011.
Thank you very much.
Not, unless I can assist any further.
Well, we're extremely grateful to Council and those behind them for their assistance, both orally and in writing. We'll take time to consider our decision.
My Lords, I apologise, but can I just be clear about where we stand in relation to Article 8?
Yes, if we need further assistance, Mr. Fordham, we'll certainly let you know. I mean, obviously, if we get to the stage of a reference, we will need further help, I think, to formulate the question. So all these matters are reserved, but we will consider our decision on what we've heard so far.